Wrong, perhaps, but not corrupt. That's how Walter Sofronoff's lawyers have described his conduct when he chaired the inquiry after the collapse of Bruce Lehrmann's criminal trial with no verdict. The ACT Integrity Commission investigated Mr Sofronoff's contact with journalists, including the disclosure of confidential material to Janet Albrechtsen of The Australian and the early provision of his final report to her and the ABC's Elizabeth Byrne. Its finding of serious corrupt conduct is now the subject of a court challenge. Mr Sofronoff's barrister Adam Pomerenke said his client genuinely believed he was acting in the public interest. This is not a corrupt, dishonest or malicious motive. At worst, it could be characterised as an erroneous attempt to ensure accuracy and transparency in public discourse. The Integrity Commission has already conceded it was wrong to make one of its findings that Mr Sofronoff may have committed the criminal offence of contempt of board. The notion that Mr Sofronoff could commit a contempt of himself is self-evidently absurd and irrational. But the Integrity Commission has pushed back on the claim that concession undermines the final conclusion of corrupt conduct. Mr Sofronoff committed a plain breach of his non-disclosure obligations that couldn't possibly be justified in relation to a function under the Act. A key issue for Justice Wendy Abraham is a disagreement over the definition of integrity. Walter Sofronoff's lawyers argue it's confined to the probity of public administration, rather than whether his conduct was sound in a broader sense. The Commission will continue its arguments tomorrow. Patrick Bell, ABC News, Canberra.